Good evening, everyone. Thank you for joining. I'm Michael Ettinger from Ettinger Law Firm, and this is our webinar, 4 Advantages of Using Trusts. By way of introduction, this is the current staff of Ettinger Law Firm. Here I am in the middle, and to my left on your screen, my lovely wife and law partner, Suzanne Ettinger, a number of other lawyers and support staff. Our website is trustlaw.com. You can also find it at ettingerplan.com. Ettinger Law Firm has been in business for 35 years. I myself have been practicing law since 1980, so for 45 years. Well, what's the difference between the 45 years I started and the 35 years we formed this firm? For the first 10 years, I was a litigation attorney. And perhaps I'll get a chance to talk about that a little bit during the presentation. But Ettinger Law Firm has been around since 1991. Our practice is limited to trusts and estates, wills and probate, estate tax saving strategies, and Medicaid applications, Medicaid trusts. We have 12 offices, 2 in Nassau County, 1 in Rockville Center, and the other in Lake Success. In Suffolk County, we have 3 offices, Huntington, where I live with my lovely wife and law partner, Suzanne, and also in Melville and in Islandia. Staten Island, we're at 900 South Avenue, the Nicotra building, everybody knows where it is. Westchester, 140 Grand Street, White Plains. Rockland, we're in New City. In Orange, we're in the Westage Center next to the police barracks and Crystal Run. Dutchess County, 2 offices. We're in Rhinebeck and Fishkill, been there for a long time, and Albany right there on Wolf Road. So I think it's fair to ask, what is elder law estate planning? And it's really a niche area of the law which combines elder law, which you've heard a lot about, but you're not quite sure what it is. It's really disability planning, and estate planning, which is sometimes referred to as death planning. And I'd like to start out by saying we use trust to create order out of chaos. We're going to begin with this, and we're going to conclude with this. And how do we use trust to create order out of chaos? Well, trusts avoid the pitfalls of wills by saving time and money in settling the estate, avoiding legal guardianship if you become disabled. Don't worry, I'm going to elaborate on each of these topics. Keeping your assets in the bloodline for your grandchildren, ultimately, instead of going to in-laws and their families, and protecting your home and life savings from the extraordinarily high cost of long-term care. Any good plan is going to cover all of these issues. And finally, what we're really talking about is control. Estate planning is about taking back control from the courts and the government and giving it back to you and your family. So we're going to talk about keeping control in the family and out of the court system. And because, as I mentioned, I was a litigator for more than 10 years before I became an elder law estate planning lawyer, I know a lot about the court system, and I would recommend you stay as far away as possible. So reason number 1, remember the 4 advantages of using trusts? The first advantage of using trusts is that trusts protect you from guardianship proceedings if you become disabled. Wills don't do that. Now, I think we have most of our participants. Some people are just signing in, but we've just got started. What you can do is you have a question. There's a place at the bottom of the screen you can type the question. We're going to hold them to the end, and then we're going to answer all your questions at the end. So again, if you just tuned in, type in your question. I'll answer them all at the end. So we're just on the first reason why trusts protect you better than wills, and we're getting into guardianship proceedings. So one of the big issues of a will is that it takes effect when you die. So it only plans for what happens after death. But today, about half of all people become disabled before they die because we're living so much longer and medical advances. So the will is no plan for those 50% who have a disability, and it doesn't cover what happens if you're sick, homebound, or disabled. Eventually going to happen to about half of us, as I say. A trust is a plan for all three phases of your life. Today, you can put yourself in charge, you're healthy and capable. It addresses who takes over and what their powers are when you become sick or disabled. And it does just the same thing as a will. It says who gets what after you pass away, but as you probably know by now, without the expense and delay of a probate court proceeding. So what are guardianship proceedings? Well, we mentioned about eventually half of all people have a disability. And guardianship proceedings are the plan that the state has written for you if you didn't do a plan of your own. And what happens there is the guardianship proceeding is started by a hospital or a nursing home. They want to get paid, so they petition the court, they want somebody in charge. Now you might say, well, I have a power of attorney. Oddly enough, a power of attorney where you appointed somebody to handle your legal and financial affairs does not stop a guardianship, because the court has the power to cancel your power of attorney and pick somebody else. Why would they do that? Well, the facility may say, that person is under our care. We want a power of attorney. They're not sure they're going to get paid. They have no control over the situation. Again, they want control if they can get it. And I know of one law firm that represents 50 nursing homes, and this is what they do full time. They go to court and try to get appointed legal guardians so they can be in charge of the money, and again, make sure they get paid. So your power of attorney, oddly enough, does not stop a guardianship. The first thing the judge does when he appoints the legal guardian is cancel your power of attorney. As the judge has the power to do that, and he doesn't want you interfering with the person that he's appointed, who's answerable to the judge or she. The problem with guardianship is the court chooses who your legal guardian will be, and it may be a stranger. You might say, well, why wouldn't they pick one of my children? They're adult, they're capable, are good members of society, citizens. But some of the judges feel your sons and daughters have a conflict. What's the conflict? If they spend it on you, it's coming out of their inheritance. So the judge may want somebody impartial. The judge may want somebody to help the judge get elected. Basically, it's up to the judge. You can't control who the judge will pick. So it's a very uncomfortable place to be because you don't know what's going to happen. It could be not only the hospital, nursing home, any relative, professional, the doctor, the lawyer can start a guardianship saying this person is being taken advantage of, this person is not handling their affairs properly, etc. The key is to avoid guardianship because once it starts, you can't put the genie back in the bottle. So once they start this guardianship, you're on a bureaucratic roller coaster, and you can't get back control without a court order, which is very, very difficult to obtain. So much easier to stay out of it. An ounce of prevention is worth a pound of cure than to try to get out of it once you're in it. Just try to prevent it. The proceedings are expensive, multiple court proceedings, time consuming, and they're very stressful. You don't know who's going to be in charge. You don't know if you like them, you won't like them. You don't know what they'll do, they won't do. Really fraught with risk. Another issue we run into guardianship is the guardian doesn't have the same options as your family does to protect your assets and long-term care costs. So we have a technique. We call it half a loaf planning. Somebody comes to us, mom's going to nursing home tomorrow, hasn't done any planning, has $300,000. We can actually save $150,000 by moving it out of mom's name, as long as we spend the other $150,000 on her care. We don't have the time to explain the whole technique, but just take it on faith for now. We could save half by moving it out of mom's name. That's if the family's in charge. If the legal guardian is in charge, the legal guardian can't move $150,000 out of mom's name because the legal guardian is the guardian for mom. So you have to apply to the court. The guardian has to apply to the court to ask the judge for permission to protect some of mom's assets. Well, I've been there with these cases. First off, you have to get the guardian to do it. It's not their money, they may not care. But I had a case that taught me a good lesson a number of years ago. I convinced the legal guardian to make an application to the judge to save half of mom's assets. And guess what? The judge turned down the application. And you know why? Because the judge said, In my opinion, its mother's money should be spent on her for her care, even if it has to all be spent on her care. So why did that happen? Because the judge was in charge, and the judge had the judge's own values that he applied instead of the family's values, which would have been, hey, let's save whatever we can. Money doesn't grow on trees, as my mother used to tell me when I was growing up. So we don't want somebody else in charge who may not do what we want, and may have their own ideas. We want our family in charge. So we want to set up a plan where the people we know and trust are in charge, and not a stranger who not only we don't know, but we don't know what they're going to do. They certainly may not act in the family's best interest, and they don't have the same concern as you do with your assets in your family. So revocable trust avoids guardianship. And how does it do that? Well, unlike a will, the trust takes effect while you're living, which is why they call it a living trust, and it stays in effect if and when you become disabled. So let's say your name is Mary Jones. You set up something called the Mary Jones Living Trust. You appoint yourself the trustee or manager of the trust, and then you retitle your assets. We'll prepare the deed from your house, show you how to do the bank accounts. We'll write to your investment advisors, and we'll ask them to retitle your assets from Mary Jones to Mary Jones, trustee of the Mary Jones Living Trust, whatever the date of the trust is. Now it's in the trust. So once it's in the trust says, if a doctor says, I'm unable to handle my legal and financial affairs, I name so-and-so as my backup trustee. It can be 1, 2, 3 people. Generally, whoever you name will be able to act independently. So it's like a joint account for the backup trustees. If there's more than one, either can act. But here's the key. There's that word control. The people you know and trust are in control instead of a court-appointed legal guardian who may be a stranger. Well, this is what I want, and this is, I think, what anybody would want. They would want their devil instead of the court-appointed devil, right? The key is now, if your family's in charge, when you recover, you take back control whenever you feel ready. You don't have to go to court asking a judge for permission to get your own assets, which permission may be denied. Now, remember I said the court can cancel your power of attorney, appoint a legal guardian? Fortunately for all of us here this evening, the court cannot override the trust. The trust is more powerful than the court's guardianship proceeding, so it guarantees you get the people you choose in the event of disability. Look, I used to say when I gave my public seminars, any of us are only as good as our backup plan. And, when you're in my job, you learn that life is very fickle. Anything can happen to anybody at any time, and it does. So we want to have a plan, and hopefully we don't have to use it. Just want to touch on the power of attorney. Not all powers of attorney are created equal. If you get a power of attorney and you're over, say, 60, 65, you want this elder law power of attorney, not the standard form that almost all lawyers use, because the standard form is not strong enough. In fact, it works like medicine. What happens if you need prescription strength and you only have over-the-counter medicine? You know exactly what happens. It doesn't work. It's not strong enough. And that's the same thing with the power of attorney. The standard form is simply not strong enough to address the issues that arise when someone becomes disabled. The main thing about the elder law power of attorney is we use it to transfer and protect assets in the event of disability. And we do that with something called the unlimited gifting power. So let me explain. The standard form power of attorney allows you to gift up to $5,000 a year. Now, if you were with us a few minutes ago, I said, if somebody's on the nursing home doorstep and they have done no planning, but they have $300,000, we could save $150,000 by moving it to their sons and daughters. There's other things, a few bells and whistles, but essentially we can save half the money by moving it out of their name. But what if you have the standard power of attorney? Mom or dad is not in a position to sign a new one, and you have the standard one that comes right out of the statute book that general lawyers prepare that says that you can make gifts up to $5,000 a year. Well, under Medicaid, it's move it or lose it. If you have $300,000, I can only move $5,000 a year. You know what's going to happen in 2 years. I'll have saved 10,000, 5,000 each year, and the rest will go to the nursing home. If I had an unlimited gifting power, I could move 150,000 and save half the assets. So under Medicaid, it's move it or lose it. If you can't move it, you lose it. So any elder law attorney will put into their power of attorney that you pick somebody you trust or more than one person, and you allow them to move any amount of money. They might be able to save $500,000 or more just by being able to move it out of their name. You just be careful who you give it to. But most people that I meet, and I met an awful lot of people, have somebody that they trust enough to give them the unlimited gifting power. And it's key, very important. So we know that a will has to go to court to settle. It's called a probate proceeding. Actually, some people think a will avoids probate. I don't know where they get that idea, but they do. Now, you only have to probate an asset that doesn't have a beneficiary on it or is not joint. Generally, that's at least the family house. But once it goes into probate, the court has control over the estate. You lose control. Who wants that? Nobody. Remember, I spent over 10 years as a litigation attorney. I was in court all the time. And as a matter of fact, this is what brought me into estate planning. So I was back in late 1990, talking quite a while ago, and I was in my car chasing an ambulance, as they say. I was on a personal injury call. And I heard on the radio for the first time about a seminar on living trusts. I said, well, that's interesting. So I picked up my mobile phone. I don't know if you remember, but back in those days, you actually had a telephone in your car. It was a real phone with a receiver and the whole thing. And I called up the seminar presenter, and he was very excited because I had a phone in my car, which was, he figured I must have been a high roller. So he was excited to get me to the seminar. And, I told him I was a lawyer, and he said, you're very welcome. In any event, I went to the seminar. For the first time, I learned that if you set up a trust, you don't have to go to court to settle. Well, I immediately realized who wouldn't want that? I just spent 10 years in court. I would do anything to keep my clients out of court. Because when you go to court, who's in charge? The judge, right? Now, when the judge says jump, your answer has to be what? And when I give my public seminars, people would say, how high? And I would say, well, no, that's not correct. It's how high, Your Honor. So I would get a good laugh out of that. Nobody wants to be there, really, with somebody else in charge of their assets. So we have submitted the will to probate. Now we're waiting for the judge to pass on the matter and approve the will and issue what are called letters testamentary, which is an official court document sealed with a seal on it, where the judge appoints the executor and says that will was valid, it met all the formalities, the person was of sound mind, memory, and understanding, was not under any fraud or undue influence, able to read, write, and converse the English language, all the formalities were met, the witnesses testified, the judge approves the will. But until that time, which could take a year or two, the executor is hamstrung, can't sell the house, can't even list it for sale. This can cause lengthy delays in getting assets to access to the house to sell. How'd you like to carry an empty house for 2 years? We have a lot of clients with co-ops in Queens. It can easily take 2 years to get the letters testamentary. In the meantime, you're paying maintenance for 2 years on an empty co-op. You can't even list it for sale. You have any money or stocks that you're not beneficiary or joint on, the market could be going up and down. You're helpless. You can't change your investments and you can't get access to the stocks. May not be able to have money to get money to pay bills. So nobody wants to be there, and you don't have to be there because today we have trusts. Probate court proceedings are costly, time consuming, and stressful. I had a client texted me today, said, how's the probate court proceeding going? And here's what he said, any update? I said, none. And we cannot inquire either. They don't like for us to ask. So they don't want to hear from us, how's it going? They don't want to hear from us, how long it'll take. You get the same answer every time. We'll let you know. And so, experienced lawyers never call and ask about the status of a probate court proceeding. Well, they still do, but it's not very effective. Wills are public records. Anybody go down and look up how much you had, who you left it to, who you left out. People value privacy today. So you can see this is kind of an antiquated system here. So the benefits of the trust are, number one, they avoid probate court proceedings entirely for trust assets. I want to spend a moment on this. Entirely for trust assets, which means to avoid probate, we have to get the assets into the trust. Now, I'm proud of where we have come from the beginning. We've been funding these trusts, getting the assets into them for decades. And we take the burden off of you. We don't charge for it because we want the trust to work. We will give you the paperwork you need to take to the bank. We can't go to the bank for you because they don't want to hear from us, but we'll give you turnkey. You just give the bank these papers and they'll do it for you. If you have financial advisors, we contact them, we send them the trust. Your deeds we do for you. So we make sure that the trust is fully funded and we pay time and attention and we do it in detail. Why? Because if we get everything in the trust, you're going to save time, sometimes a year or two. You're going to save legal fees, much less expensive to stay out of court than go to court, obviously. And you're not going to have to pay court filing fees, which generally run, a lot of them are about $1,250 to file the papers. But here's the big thing. It's all about control. We're avoiding court control of your estate. You don't have to worry how long it'll take, whether it's going to get approved, what are the proofs the judge going to want. I once had to prove to a judge that somebody 125 years old was no longer living. Even though the longest living human being ever in history was 122 years old, I had to prove somebody 125 wasn't living. And why do they do things like that? Because the more trusts are set up, the less work there is for the surrogates court. It's called the probate court in New York. They have a fancy name. It's called surrogates court. The less work they have. The less work they have, the more they pay attention to each case to justify their jobs and their salaries. So they can get very, very picky and put you through hoops to get the thing done. That's why I don't like to go there. So the difference with the trust on death, the backup trustee can act immediately. Doesn't have to wait for the judge to approve. What do they have to wait for? A death certificate. Takes a couple of weeks. The death certificate proves that the backup trustee is acting because the trustee is no longer there in a revocable trust in any event. You just joined us, or if you're from before, reminder, you can type any questions you want to the bottom of your screen. We'll answer them at the end. Now, this backup trustee can act immediately is very significant. Get the house cleaned out, listed for sale. Nobody's in charge of you. You're not looking at carrying an empty house for a year, sometimes 2 years. These trusts are private because it doesn't get filed in court. Nobody knows how much you had, who you left it to, who you left out. Nobody's going to take advantage of your heirs because they're not going to know how much they're getting or when they're getting it. So we like the privacy aspect. So do our clients. People cherish privacy today because they understand how valuable it is. And, we all get more than our share of solicitations. But imagine all the solicitations you would get if there's a public record that you're coming into money. So I want to avoid that. Also, if you're leaving somebody out or you're leaving them less than they think they're entitled to, it's going to be much harder to contest a trust. Now, a will contest is relatively easy because everybody gets a notice, even the people who left out, the people who are estranged from, they all get notice. And all they have to say is they don't agree, they object, and we're in a will contest. Do you know that will contests are often settled in favor of the illegitimate heir? Now, why would that be? Because once a will contest is started, the legitimate heirs can't get their share unless they fight the contest, which can take years, or they settle with the disgruntled heir. What do you think they're going to do? They're going to settle because they want to get their money. So the lawyer challenging the will has the procedural advantage. Nobody gets anything until they deal with that lawyer. With the trust, no such thing. Because it's not in court, the trustee distributes all the assets. Now, if somebody's challenging the trust, they have to run after all the beneficiaries because the money is already gone. You can't stop a trust from being distributed. So lawyers don't like to challenge trusts because the money is no longer there. Nobody wants to chase, the horses after the barn door has been left open. So not only are trusts harder to contest procedurally, but generally judges feel that if somebody was sophisticated enough to set up a trust, they probably knew what they were doing. So the bar to challenging a trust is much higher, harder to get a lawyer to take. We're also looking at avoiding something called the multiple probate problem. So let's say you have a house here in New York, rather modest, would say, and one of these pastel-colored condos in Florida. Well, you have to probate in every state where you own real estate, but they don't happen at the same time. Before you start Florida, you have to finish New York. They come one after the other. It's called the multiple probate problem. But you can deed your property from New York and Florida into the trust and avoid these multiple probates. So the first reason trusts are preferred over wills, they avoid guardianship proceedings where you lose control. The judge appoints often a stranger to handle your assets. The second one, the famous one, trusts avoid probate. I think most people know that, and they know it's a good thing. It saves time and money, and you have control instead of the judge having control. Let's move into reason number 3. Trusts protect the inheritance you leave from your children's divorces, lawsuits, and creditors, and keep your assets in the bloodline for your grandchildren. Wills don't do this. This is called the Inheritance Protection Trust, something I invented myself in 2008. So soon it'll be 20 years we've been doing it, done tens of thousands of these trusts. And these trusts do what they say. They protect the inheritance. Instead of leaving it to the son, you leave it to the trust. Instead of the daughter or son directly, it goes to the trust for the daughter or son. Okay, so you can leave it to them in trust or directly, but we're going to talk about why we want to leave it in the trust. The son or daughter is the trustee of the Inheritance Protection Trust. They can spend whatever they want. They could buy, sell, trade, spend. They can spend the whole thing. You're not ruling from the grave. But unlike leaving it to them directly, this protects them if they get divorced. It protects them if they get sued. And the key, it protects them from the assets going to your son-in-law or daughter-in-law and their families. So you leave your daughter $1 million. Unfortunately, dies before her husband. In most cases, the husband gets $1 million, gets remarried. Your grandchildren never see a penny of that money. Happens every day. With the Medicaid Asset Protection Trust, with the Inheritance Protection, I'm getting ahead of myself. With the Inheritance Protection Trust, it doesn't work like that. It goes into a trust, your daughter's in charge. It says if she dies, it goes to your grandchildren. So your money stays in the bloodline. Very, very popular. I had a case a few years ago. Client, it illustrates the problem. This fellow, Schwartz, came into my White Plains office and he introduces his fiance, and he wants to leave half of his $1 million estate and this is many years ago when $1 million was more than it is today. And he wanted to leave his estate half to his fiance and half to his daughter. I said, fine, Mr. Schwartz, come back in a couple of weeks. I'll have everything ready. Daughter calls me the next day and says, my mother's turning over in her grave. Says, the $1 million was my mother. She died and left it to my father. I've been his daughter for 52 years, and he meets this woman 6 weeks ago and he wants to leave it half to her and half to me. It's outrageous. I said, I'm sorry, but he's competent. He can do what he wants. There's nothing we can do about it. It's a funny story because 2 weeks later, Mr. Schwartz comes in with his fiance and another woman. So I said, Mr. Schwartz, who is she? This other woman. He says, well, that's my lawyer. I said, well, I thought I was your lawyer. He said, well, a man can have 2 lawyers, can't he? I said, of course he can, but not here, Mr. Schwartz. So at the time, we used to take a retainer, which we don't do anymore. You'll see later. We only get paid at the end. I prefer it that way. I went to the bookkeeper and I said, how much did Mr. Schwartz pay us? Please give me a check. I went out, I gave him his check. Here's your money back. Goodbye. Find out the next day who was the other woman. She was the cousin, the lawyer was a cousin of the fiance, who came to make sure her 50% was nailed down tight. So lesson learned, can very easily go out of the family unless you set up the IPT, Inheritance Protection Trust. Very, very popular. Most people do it these days, the ones who find out about it. You can also protect the beneficiaries against themselves. Now, there is no doubt that some people listening have this problem. They have beneficiaries who need to be protected by having somebody else as a trustee or co-trustee with them. It could be substance abuse, it could be inability to handle money, it could be learning disabilities, special needs, alcohol and abuse problems, a spouse that tells them what to do, they're bossed by somebody else. All these things we can protect them with the Inheritance Protection Trust. We'll talk about your particular situation when we see you. But as I've written in my book, I have many chapters on the social side of estate planning. And as you get to know us, you'll learn that we actually believe that you have to do the social work first and the legal work second, because the legal has to serve the social. And if you don't do the social work and get to understand the family and their needs and the dynamics, you generally can't prepare a good estate plan because you overlook the most important part. They don't teach this in law school. This is self-taught from experience with tens of thousands of cases over the last 35 years. Have to do the social work first. So here we are. Let me get my screen. Oh, get busy with this thing. So we can make that small. There we go. Well, small as I can. I don't even know if you can see that, but put me over there. Okay. Here's our lovely family. There's mom and dad, children, grandma, grandpa. We want to pass this inheritance by blood instead of to in-laws. So this trust will pass inheritance when mom and dad are gone to the kids and not to the in-laws. Now, what if they don't have children? Then it goes, so if you leave it to your sons and daughters, their share goes to their children. If they don't have children, it goes back to their brothers and sisters, and then it'll go to the nieces and nephews. It always stays in the blood. Now, some people are very fond of their daughter-in-law. We'll say, Mary's the daughter-in-law here, and they don't want to leave her out. So what you can do is you can say, I'll give an example. When Bobby here dies, if he's still married to Mary and they're cohabitating, still have to be living together, okay, give half to the kids. If they're under 35, it's in trust with another family member of your family managing it for them. Use the money for their health, education, maintenance and support, college, down payment on a house. And when they reach 35, whatever wasn't spent, we give to them. But you could say, well, if they were still married and living together, give half the kids, keep the other half in trust for Mary, give her an income for life on her death, give the kids the second half. So because we create a trust for Mary, it doesn't go to her husband if she gets remarried. It still stays in the blood, but she gets a lifetime income interest. Don't worry. If you don't follow everything, you don't get everything. If you choose to come in and see me, hopefully in the office, possibly by Zoom if you can't make it, I'll explain all this again and again and again. And we have a way to make you knowledgeable. We direct you to the videos on our website, which you can watch anytime, especially the first one, which is a version of this. When you come into the office, we'll give you a copy of my book. It's in plain English, my third book on this. You can read about it. So don't worry if you don't get everything. You're going to get quite a few bites at the apple, because we have an expression here at Ettinger Law Firm. We say, if you don't understand the plan, you don't have a plan. We don't do the plan unless and until you understand it, and we have ways of making it clear and simple and understandable. The key here is when you set up the Inheritance Protection Trust, your careful planning continues for decades after you're gone. It's a true legacy. So we get to the fourth and final reason why trusts have advantages over wills, because trusts protect your home and life savings from long-term care costs. Wills don't do that. So now we're the famous MAPT. You put your home and other assets in the MAPT, and allows you to qualify for Medicaid benefits for home care or facility care if and when you might need that. Put me back up there. Now, the way the Medicaid trust works, it sets up three roadblocks that Medicaid cannot break through. First, it's an irrevocable trust. Now, right away, when people hear the word irrevocable, they get scared. Oh no, I can't undo it. I don't want that. I had somebody today saying, I want a revocable trust. I don't want an irrevocable trust. Well, shouldn't really know that much about revocable or irrevocable or the differences. So I said, why don't you wait and see? This is like going into the doctor and saying, doctor, this is what I have and this is what I want you to do. That's not going to go too well. Uh, and if you go see a good lawyer, the lawyer is going to look at your situation, make the recommendations based on what they see, not on what you want. Um, more, what do you need and why? So the reason uh, irrevocable trust can be revoked is, or the reason it's called an irrevocable trust and you can revoke it is this. It's irrevocable because you, the person or persons, could be a couple who set it up, you can't revoke it yourself. So law says, so far as you're concerned, that's irrevocable, you can't undo it. But in New York, we have another rule on the books that says that if every person named in an irrevocable trust agrees in writing that they don't no longer want the trust, you may revoke it on the written consent of all the named parties. I'll tell you a little later, uh, um, when I get to it, how you can actually revoke it even if one of them won't sign. Um, so the key is somebody else has to be the trustee. The trustee is the manager of the trust. It's usually one or more of the adult children. You're the beneficiary. You have the exclusive use and enjoyment of the trust assets. You live in the home, you pay the taxes, you mow the lawn. But their name is on the deed as trustee of the Jones Family Trust. But the trust is exclusively for the benefit of mom, dad, or if there's a couple, mom and dad. So you have the use and enjoyment of the house. What about investments? Well, the trust is called an income-only trust, and it means what it says. You only get the income. That's interest on CDs, dividends on stocks, etc. So let's look at who sets up these trusts and why they do it. Middle-class people set it up. It doesn't affect your lifestyle. You still get all your income. So you're going to get your Social Security, your IRA distributions, your pensions, your rental income. All income continues. We're only talking about protecting assets. Assets you can move out of your name. Income you can't move out of your name because it keeps coming in. It's not an asset. So it makes sense for assets. You're not going to spend like your home. Of course, doesn't matter to you if it's in a trust. You still have the same use and enjoyment of it. You pay the taxes same as before. Nothing changes. And what about investments that you don't need the principal, you're only taking the income, or sometimes you're not taking the income, you're just reinvesting it. Well, if you don't need it for you, why should you be safe keeping it for the long-term care industry? Instead, put it in the trust, keep it for your family. So as I said, you have the exclusive right to use and enjoy your home. You have control of the trust by retaining the right to change the trustees at any time. So you pick son or daughter as trustee, you have a falling out, or you don't like how they're running it, you can fire them. Come to me, I'll take care of it for you. Okay. What does this mean? You have control. Uh, Actually, not only can you change the trustees, but you can change who you leave it to. So remember I said you can revoke it on consent of all the named parties. Everybody signs, you're going to do it. What if one of them won't sign? Not a problem. I take them out as trustee. I take them out as beneficiary, because remember, you can fire the trustee, you can change the beneficiary. They're no longer a party to the trust, don't need their signature. You have the other one sign it. So what this means is you can always revoke an irrevocable trust, at least if it's an Ettinger trust, and you have control over it. You're still in charge of this whole thing. Now, very few people know this. Most lawyers don't know it. And a lot of lawyers don't prepare the trust this way. They don't make it this flexible. And the reason, I was explaining this to somebody today, there are way, way more trust lawyers, elder law attorneys preparing these trusts than who file Medicaid. We filed over 5,000 Medicaid cases. So we're quite liberal with the trust because we know what Medicaid will accept. Because they don't know what Medicaid will accept, they make it more restrictive because they're afraid they won't get approved. So uh, for my money, I would want to have this Ettinger trust because it's like having your cake and eat it too. You put in your irrevocable trust to protect it, you change your mind, you take it out. You can undo the trust. You don't like how the person's running it, you can change the trustee. You have a falling out with one of the kids, you can disinherit them. I hope that doesn't happen, but it's nice to know that you have that control. So unfortunately, most of them I see don't have one of these benefits. Either you can't get the money out by gift, you can't change who you leave it to, you can't change the trustee, which I think is very unfair because when people come in and they've lost these powers, I say, I'm sorry, the lawyer painted you in a corner. I sleep well at night because I can undo anything that I do, and I think it's a great, great thing. But remember, I was a litigation attorney, so I like things that work, and I know the system, and we've been very successful with this trust over the years, prepared tens of thousands of them. and you just can't, there's nothing to be afraid of. If you read my column, every Thursday I write a column, and anybody's listening, it's in your local paper. It's in the Gannett in Westchester. It's in the Albany Times-Union. It's in Newsday, a number of other local papers. Uh, I wrote a column on the misconceptions with these Medicaid trusts, and the title of my column is, "When it comes to elder law estate planning, there's more misinformation than information." And boy, is that true. People come in all the time. I read this on the internet. I read that in the internet. Well, first of all, there's different quality information, but it might be from another state. It doesn't apply to New York. You know what I tell them? I say, read my book. It's my third edition. It's 15 years old. Nobody's found any mistakes in it. Every lawyer has read it, every elder law attorney. Many people in the public read it, thousands and thousands of people. So that book is vetted. So you need to get the right information. And this book is written in plain English. As I mentioned in the beginning, you come into the office, we'll give you a copy, a free copy. And we'll tell you which chapters apply to you as well. So now you have the trust, you can only get the income. So if you need Medicaid, either a facility or a home care, they can only get the income. My nest egg is protected for my children. Great thing. Look, you did a great job building up whatever you have. This is just the last 10% we had protected. So let's get into this trust. The trust can sell the house and trade stock. I've seen lawyers tell people, well, it's irrevocable trust, you can't sell the house. Oh, really? We've done it thousands of times. The trust sells the house, the money's paid to the trust goes out and buy a condo, it's still protected. You don't start to 5 years over again. You can buy and sell and trade stock. So you name your son or daughter the trustee, but you like to trade the stock. Well, what they can do, there's two ways to do that. They can take out a PIN, and it's online. They give you the PIN, you go in and you trade, or they can sign with your investment advisor something called a third-party authorization. I, the trustee, authorize mom or dad or both to trade on the account. So you can always continue trading even if it's an irrevocable trust. We know there's a 5-year look back for facility care, and they keep talking about a new and a 2.5 year look back for home care. Always threatening, hasn't passed yet, don't know. But hey, I mean, I want to have my trust more than 2.5 years before I might need home care in case they do pass it. Now, I said you can't only get the income. What if you need the principal? Well, sure enough, there's a way to get principal out of the trust. You can gift principal, any amount tax-free, to your children or grandchildren. Now, can they give it back to you? Well, no. They can't give it back to you because then it'll show up in your bank account. Medicaid will say, well, where did that come from? That 25 or 50,000. And if it came from the trust, you're sunk. The trust is invalid. So, and the reason for this is when I apply for Medicaid, I have to show them what you took out of your name and put into the trust. But I don't have to show Medicaid what the trust gave to somebody else. So you want to take your whole family and your lawyer around the world on a beautiful trip, by all means. Make a gift to your son or daughter, 50, 60,000. They'll pay the travel agent, and off you go with your lawyer. What about IRAs, 401ks, 403b, 457? All these plans now defer to age 73. These are exempt. Medicaid can't go over after your retirement plan except for RMDs. What are those? Required minimum distributions. That's income. You have to take it. If you need care, Medicaid will grab that. But that's, that's 4% a year. That's not going to be 20,000 or more a month at a cost for care. So you'll still save a lot. Now, it always pays to get started because it prorates. Let's say you set up the trust. 3 years later, you end up in a nursing home. You only have to pay for the 2 that are left. You already have 3. So it always pays to get started because it prorates. So we started with what we're going to conclude with is trust create order out of chaos. So first, we're going to avoid guardianship with disability. We're going to keep control in the family, away from the courts, no chance of a stranger taking over assets, and we have all the asset protection options, because what happens if you're a client of Ettinger Law Firm and you become disabled? Well, your sons and daughters are going to come in to us and they're going to say, now what do we do now? We're going to say, well, here are your asset protection options. You can do this, 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 or this. This is the one we recommend and why. This is how it works. and off we go. No delay, nobody else's permission. Your family does what's in your best interest. So that's guardianship we avoided. We have a plan for disability. We're going to be able to save and protect assets. We avoid probate on death. I like that because nobody wants to submit it to court and have, like my client is asking me, why is it taking so long? Well, what's the status? You don't have any control and you can't even find out. So we're going to keep control in the family to save significant time and money in settling the estate, and keeps your affairs private. Privacy is very valuable. You don't want the whole world to know how much your heirs are getting, where they live, and when they're getting it. So we save time and money. And it also helps the grieving process not to drag out for a couple of years. This protects the inheritance you leave from your children's divorces, maybe 50%. I think it's now around 43% to be accurate. They can get sued. They got a medical problem. I run up a big bill for unforeseen medical expense. Creditors, things happen, run into financial problems. But it's protected. This nest egg is protected not only from your sons and daughters, but your son-in-laws and daughter-in-laws could have financial problems. This is a nest egg that will help the whole family. And then when your son or daughter dies, it passes by blood to your grandchildren instead of to in-laws and their families. If your son or daughter doesn't have kids, it goes to their brothers and sisters and then to nieces and nephews. But it keeps it in the blood. And finally, it protects your home and life savings from the extraordinary costs of long-term care, makes you eligible for Medicaid for home care and facility care if and when you need that. So this is order, and without it, it's chaos. Let me take a moment, if you would, talk about our unique planning process. This is my new guide, 2025 edition, Ettinger Law Firm's Guide to Protecting Your Future. I wrote it. And your process began with this seminar. So now you have some ideas. We offer a no-cost initial consultation. What are we going to do? We're going to ask you to bring in your current plan, will, trust, power of attorney. We're going to do an audit on that. We'll look it over and we'll tell you if it's adequate, it's not adequate. If it's not, we're going to explain what the issues are in plain English so you'll understand. We explain it to you. This is what's missing. This is what you should do and why. You get a free copy of my book, which I mentioned, and we'll tell you which chapters apply to you. Once we size up your situation, we'll generally tell you this is how much it will cost, and this is what we're going to do for the fees. And now we're going to ask you to set up a second follow-up consultation. Again, no cost. Come in and have your questions answered. Which questions? Well, whatever you thought of after the first meeting, plus whatever questions you have arising out of you reading the chapters in our Guide to Protecting Your Future. So now you come in for your second no-cost consultation. We're going to answer your questions. We're going to draft the estate plan together with you. What does that mean? Who do you want to make medical decisions? Who's your first choice, second choice? Who do you want to handle your affairs on death or disability? One person, two people. How do you want to leave the estate? Equal shares, unequal shares. You want it to pay out in one lump sum or over time or in stages or installments. And all the other questions and issues come into drafting an estate plan. Then once we have the estate plan together based on our input and our experience is very, very valuable in drafting an estate plan, because if you're talking to an experienced estate planning lawyer, they already know what's going to work, what won't work, and why. Happens every day. Clients come in. I had a client come in today, 4 children. They don't get along. Some with the others. Some live in the house with the mom. Some don't. Some live in another house the mom owns. Just a complete mess when mom dies. So we made some suggestions, and we're going to work on them to have a plan that will work, that everybody understands and agrees to ahead of time. But that's really preventing chaos. I don't know if you remember, I think it was a year or two ago, somebody was who lived in the house their whole life was being asked under the terms of the will. The brothers and sisters wanted to sell the house, and he was going to be out of the house. He lived in his own life, and he went and he shot up the whole family. Horrible story, but that was partly because it wasn't realized that would be problematical after the parents were gone, that they didn't have a plan to address his needs adequately. Nothing justifies what he did, but you can see, I see it all the time. Children who've lived in the same house their whole lives are really cast adrift mentally, socially, psychologically. If the house has to be sold and they're out on the street, they don't know where to go, they don't know how to handle things, all kinds of issues arise. Um, and you may have your own issues. You know, you could have bossy son-in-laws and daughter-in-laws. You could have uh, children are married to borderline personality disorder type people, all kinds of issues. So you want to experience, what you really want to know is, what are my options? What do other people do in these situations? Why do they do it? Most of these issues are discussed in my book. But we're going to give you a detailed written proposal for the fees quoted. And now you say, okay, well, that sounds good. We want to go ahead. Fine. We'll set up a third meeting. Unique among law firms, I believe, in the country, we do not have a retainer agreement to sign. You don't sign anything. We give an agreement, we sign it, you don't sign it. Our agreement says we're going to do all this whole list of things, but no fees are due until after your documents are signed, which means what? It means you're in control. Here's what we figured out. I think it's about 10 years ago, maybe more now. We figured out that the retainer system, I was trained in this, I didn't know any other way, and every other lawyer is trained. When somebody wants to go ahead, you give them a check for half the fee to go ahead, and the balance when they're done. But we realized, once we analyzed that and we got more experience, that what basically is happening is, when you give the lawyer a check for 50%, what do you have? Nothing, right? You have a promise. You have to hope the lawyer is going to perform. You have to hope that you'll be satisfied with what the lawyer did. Um, so there's no use me giving a seminar. I guess I realized this one day, more than 10 years ago. No use giving me a seminar talking about taking back control from the courts and the government. And the first thing that happens, you come to our office, is we take a check and you lose control. So what we figured out was, it's much better for the client. They don't pay anything till we're done and they're satisfied. Because what this does, it puts the client in control. Obviously, the best place for the client to be. Now, if we're here to serve you, and the best place for you to be, we feel it's the best place for us to be. So we've been very successful with this program. No retainer, you don't sign anything, you don't pay anything until after the documents are signed. So the final meeting, we review, sign the documents, and you pay at the end. Cash, credit cards, we get 3% now because everybody does that. You got to pay the credit card company. So people often pay by check. It can be at once, or you could do it in 3 equal monthly installments. So after the sign your documents, we don't say goodbye. We say, hello, welcome to the firm. I was at a continuing legal education seminar years ago, and they said, after the estate plan is signed, we should send you a letter saying thank you very much for your patronage. This concludes our representation of you in this matter. They are just to tell you goodbye. Why? Because if we made a mistake, you can't sue us after a few years. The statute of limitations has run. Imagine that. Who is the bar concerned about? They're concerned about the lawyer. What about the client? Well, it doesn't work very well for the client, because most plans are created decades before the client dies. Who says it's going to work if nobody's looked at it? So I don't think much of the advice that was given at that bar meeting, and I know why they give that advice, because lawyers are more concerned with the 1 in 10,000 clients who are going to sue them than the 9,999 that aren't. And we're the reverse. We're more concerned with the 9,999 that aren't going to sue us than the one who is going to sue us. And besides, we're insured if somebody sues us for whatever reason. We're not worried about it. So we don't say goodbye. We say hello. Welcome to the firm. We are going to be there for you. We're going to keep you up to date of any law changes and other matters through our weekly Ettinger Elder alert. It comes by email. Been writing it for, decades. So you'll know about any law changes that are coming. But the key is this: Ettinger Law Firm calls you in for a complimentary free review of your estate every 3 years. We call you in. Don't wait for you to call us, because we'll never hear from you. Who's going to wake up every 3 years and say, I have to call Ettinger? Nobody. So we do it for you. We track it. We take responsibility. We ask you to come in, see if there's any change in your health, your assets, your family. What about the laws? Are your documents up to date? Any births, deaths, marriages, divorces, etc. We want the plan to work when you need it, not when you wrote it decades earlier. We don't charge for phone calls, emails, or questions. Why? Because if we charge, people wouldn't ask and they wouldn't know. We want people to communicate. I can't tell you how many times I have to tell people, and I'm telling you, and I mean it, it's no bother. Call anytime. Happy to answer your questions. I want clients who are comfortable, not stressed. Let me pull this in. Okay, this is what I keep on my desk, right? Facing the client. You see what that says? No. Well, oh, there you go. Okay. No worry. You get it right up in the right spot. No worries. You see that? Well, that's what you come to a lawyer for. So you won't have worries. So we're going to encourage you to stop worrying. Um, and there are a lot of worriers out there. So let me see if I can find something for you worriers. Da, 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 da. Bear with me a moment. Just a moment. Well, I can't find it now, unfortunately. But I was going to tell you about worry. You know, I was just in Newfoundland, which is off the coast of Canada, and they have an expression about worry that goes something like, don't go out and meet your worries, wait for them to come to you. So that's just what I was trying to find the quote. Not successful, but um, we try to avoid worry here and help people de-stress and not worry about the things that we're dealing with, and hopefully help them not worry about other things as well. Let's see what else we have here. The key is this: by using this program, your plan is never more than 3 years old. It's designed to work when you need it, not when you signed it decades earlier. We have saved countless thousands of people, countless thousands of problems by this program. I'm very proud of it because I know if you have an Ettinger plan, it's going to work when you need it, and that's what you need. So we keep it up to date for you. It actually makes for a better plan. And think about this: I don't have to plan for the rest of your life. I only have to plan for the next 3 years. I don't go and see you then. So it's a better plan. It's now for now, and tomorrow will be tomorrow for tomorrow. And we also have a succession plan here at the firm. We have younger lawyers in their 40s, 30s, 20s now, so that the firm is designed to go on past all of our lifetimes, and they'll be there when your children need it. So if you'd like to come and see us, schedule your no-cost consultation. Uh, all our lawyers are trained in the same way. We all use the same system. It could be with myself. My wife and law partner, Suzanne Ettinger. She's very, very well thought of and very capable. She runs Islandia and Melville. We both run Huntington. I'm in occasionally in Staten Island. Actually, I run that office. I'm there generally once every 2 weeks, but it's getting busier. So in September, we'll go to once a week. I go to White Plains regularly, and I'm in Lake Success and Rockville Center. You can call us. We prefer to meet you in person. It's more effective. But if you can't make it, we'd be happy to set up a Zoom or even a phone. Call us at the 800 number or visit us at trustlaw.com or ettingerplan.com. They both go to the same website. Okay, now we are done with the screen sharing. We can stop that. We have some questions. We have 24 questions, so let's go. Anonymous, do we have to include stocks and bonds in a trust or only real estate? Well, you put in the trust what you want to avoid probate. Of course, stocks, you can have a beneficiary, it's a TOD, but if it's going to go to inheritance trust, it's better to put in my trust. And if you're protecting it from long-term care, you put in the trust. It's the same trust that holds the stocks and bonds and real estate. We do the stocks and bonds for you. So the answer is yes, they get included. What are the tax benefits of creating a trust? Are there any tax benefits that can be realized now? Well, the trust is tax neutral. It doesn't affect you tax-wise unless you're over 7.2 million in New York. Then there's a tax benefit of setting up two trusts. If you have a spouse, you double the 7.2 exemption from tax to 14.4. But if you're under the 7 million, one trust, tax neutral, doesn't affect you tax-wise at all. In other words, tax-wise, you're the same as if you didn't have a trust. And that's revocable or irrevocable. Same thing here at Ettinger Law Firm. They're both tax neutral. Anonymous, is it advisable to make an outright gift of securities to my beneficiary? Could the beneficiary be the trust? Well, yes, you can leave it to the trust, and the trust will say where it goes. But you want to give it at death because you get the new basis, the stepped up basis. And if you don't know what that is, it means that whatever you paid the stock, the value for capital gains changes from what you paid to what it's worth on the date of your death. So the heirs get a new basis, date of death value, and they don't pay. If they sell the stock, they pay no capital gains. If they hold on to it, they only pay capital gains from the time of your death to the time that they sell it. Anonymous says, what happens if you already have long-term care insurance? What are the next steps? Well, I want to know when you come in how long the duration is, how many years, and what's the daily benefit, and what's the rider for inflation. Is it 3%, 5% compound or not? And we'll take that into account along with your income and determine whether or not you should have a revocable or an irrevocable trust. Joyce C. says, do investment accounts that have designated beneficiaries need to be in the trust? Yes, if you want to pass them to the inheritance trust, they do, Joyce. And also, if you want to protect them from long-term care, they need to be in the Medicaid Asset Protection Trust. How much does it cost to create a trust? Well, it depends, revocable, irrevocable. It depends if you want an inheritance trust. If you do, how many kids do you have? But I would say these days, average between 6 and 10,000 you could expect to spend per trust. But it's a one-time fee. There's no maintenance fees. There's no ongoing fees. It actually saves money. I don't know if that sounds like a lot or a little to you, but it so greatly reduces the cost of settling an estate that it's actually a considerable savings to set up the trust and not to have it. Carnell J says, I hope you'll cover this in revocable and irrevocable. Well, I hope I did, but revocable trusts avoid probate. They say who takes over if you become disabled, but they have no protection for long-term care. They don't make you eligible for home care or facility care. Russell G says, does a home and a revocable trust get a stepped-up basis on my death? Yes, it does. If it's revocable or irrevocable, it gets a stepped-up basis. And the revocable and irrevocable both preserve the $500,000 exclusion on the sale of your home for a couple, or $250,000 for a single. That's a primary residence. Anonymous, after the trust is established, what other ongoing costs are there when you need to change items within the trust? Well, there's no fees to add assets or take assets out. The fees occur if you want to change who's in charge or who you leave it to. You know, that basically depends on how complicated the amendment is, but nobody is going to have a problem affording an amendment to a trust. Anonymous, we have revocable trust, are only two condos in it. All other assets of named beneficiaries, contingent beneficiaries. Well, that doesn't protect any assets from long-term care. So if you don't have long-term care insurance and you're getting on, you may want to reconsider and use a different trust. Joyce C. is back with another question, and that is, does the inheritance trust remain in effect after death so that the assets are protected for one's son or daughter? The inheritance trust actually is a standby trust. There's nothing in it until you're gone. And it's a separate trust, and it gets funded at your death. So it only starts when you die, goes from your revocable or irrevocable trust into your sons and daughters' inheritance protection trust. Anonymous asks, there are some negative reviews. Can address why your firm hasn't made all clients happy? Is that even possible? Well, I think that's a great question. I would say I have maybe 5 or 6 negative reviews. I have over 400 5-star reviews. So, hey, you can't win them all. But look at the negative reviews. And you can see these people, a few of them are clearly unhinged. You know, they have an axe to grind. Most of them are not clients. They're sons or daughters of clients. They were never clients. So I don't want to harp on it, but you can't make everybody. But the odd thing is, they weren't even clients. The two worst reviews were not clients. Their parents were clients. Um, so who knows? Can't win them all. Anonymous, I'm curious about the Medicaid estate recovery for a home. I've read that the primary home doesn't count towards eligibility, but be considered when someone passes to count towards the cost of their care. Yeah, you know, if your home goes through probate, then the probate court gives Medicaid a notice that, hey, there's an asset there, you can put your lien on it. If you have a trust, there's no Medicaid recovery from a trust. That's why we like trusts better than wills, because Medicaid can't go after your assets either. It's a good point. I didn't mention it, but I probably should, that they prevent Medicaid estate recovery. Monica P. wants to know if I'm licensed in North Carolina. No, but Monica, if you have a pen, I want you to write down the following acronym. Write down NAELA.org. This is the website of the National Academy of Elder Law Attorneys. And you can search for an elder law attorney in any, by zip code actually. So you can get one within 5 miles of your house or 10 miles. You can scroll out 25 miles. I recommend look at the websites, pick a couple you think are good from their website, meet with two, and if you meet with two, one will be better than the other. And you'll like one better than the other. They may not be better than the other, but you'll like one better than the other, and you'll pick the one you like. You don't need three. Two is plenty, because you're doing your due diligence by looking at their website, and you don't want to waste your time and three people's time, and you're only picking one. So I think two is fair. In New York, we have the new transfer on death deed. It can keep you out of probate, yes, but there's problems with the transfer on death deed. First, it doesn't protect your assets in long-term care. There may be no asset by the time you pass. Also, you got to leave the house to children. Let's say this is 3 children. Nobody's in charge. They may not agree on how much to sell it for, who to list it with. I like the trust because the one you want is in charge, and the other ones, well, they have to tell them what's going on, but they don't need their permission. It's good to have somebody in charge. Michael G says, my trust only has my home included. At some time, would it be beneficial to include my investments and my wife's investments in stocks and bonds? Well, you know the rule, Michael. It's a 5-year look back. So, you know, be your own counsel and figure out when you think that might be wise. If you like, you can talk to me about it, but that's my advice. Joyce C is back. Hello, Joyce. So you need, you reminds me of a joke. You know, have you heard this one, Joyce? Fellow goes into a lawyer, says, how much do you charge? Lawyer says, $500 for 3 questions. Fellow goes, wow, isn't that kind of high? Lawyer goes, yeah, what's your third question? So this is your third question, Joyce. So you need 2 trusts. The revocable living trust, no, you only need 1 trust, because if you set up an irrevocable trust, you don't need the revocable. You're not going to leave that much out of it. Whatever you leave out of it, you make joint or put a beneficiary. Okay? So you only need an irrevocable or revocable. Rarely do you need both. Number of anonymous, the number of participants not displayed. Any glitch is not a glitch. I think it's only for mine. We had 62 people with us tonight. There's no glitch, no secret, it just doesn't show up on your screen. Anonymous, how is filing taxes changing procedure of the trust? Revocable trust uses your social security number. There's no change in the filing of taxes. Irrevocable trust has to file, it has a different tax ID number, but it doesn't pay any taxes. It files an informational return that tells the IRS all the income from this trust is going to mom or dad. They'll pay the tax on their individual return, same as before, same as if you didn't have the irrevocable trust. You have to report the trust, but there's no tax. I have a letter for your CPA how to do that. I'll give it to you. What is an average fee? We said between 6,000 and 10,000, depending on whether revocable or irrevocable, and depending whether you want inheritance trust and how many you want. Do you draft the will or does a paralegal? No, our lawyers do all the drafting. The paralegal prepares the documents. The client meets with me or the other lawyer, the 2 consultations, and we work with the paralegal on the signing, but we're there for the signing. I mean, you don't get passed off at Ettinger Law Firm. You stay with the lawyer. If it's me or Suzanne or any other lawyers, you stay with them right through the process. We don't pass you off on somebody else. because we're building a relationship. How can you build a relationship if you pass somebody off? So we also do the reviews. Are there costs for the revision of the irrevocable trust? Yes, between 1 and 2,000, depending on the complication of the amendment. Is your entire team equally experienced? Well, no. People have various levels of experience, but we have a number of lawyers that have more than 10 years experience, and we do everything. We have systems and processes, and we meet regularly. So I would say my team can handle everybody's situation. If it's more complicated or the significant assets, they just call me in. And I handle the more difficult cases or the larger estates. But with Zoom today, you can always call in another lawyer right into the meeting. It's really quite easy. So I would say that you will get the same for 90% of people don't need me. I meet with people anyway, but they're going to get the same quality and the same representation no matter who they meet. That extra 10% is going to meet with me after they meet with the initial lawyer who determines that I need to be brought in for whatever reason. We live in Indiana. Dwight B says, I live in Indiana. Don't need to be, well, I don't need to be licensed in Indiana to help you with the trust, but what about the will and the power of attorney health proxy? Take my advice. Go to that website, naela.org, naela.org, the website of the National Academy of Elder Law Attorneys, and interview a couple and pick the one you like better. Russell G says, what about a TOD deed? That's a new since July of last year. We have the transfer on death deed, like the Lady Bird deed in Florida. You can put a beneficiary on your deed, and you can take them off if you change your mind, so you don't need their signature. But it avoids probate, but it has a few problems. One is it doesn't protect your assets from long-term care. And also, you leave it to 3 or 4 people, it's rare they're going to reach an agreement on how much to sell it for, who to list it with. I like the trust where you have 1 or 2 people in charge and the other ones have to live with their decisions. It's much better to have 1 or 2 in charge the most. Hi, Michael. Ramona W. says, what are the downsides of a trust? Is it necessary to have a will and a trust, or does the trust cover everything? Well, I've been asked many, many times over the years, what are the downsides of a trust? Well, if you don't need it, it's an expense that you don't need. And I tell you if you don't need it. People come in who say, I want a trust, and I explain to them, well, you're not really a candidate. Doesn't I see, Judith, you raise your hand. Go ahead and just type in your question. I'll get to it at the end. The downside of a trust is if you don't need it, it's an unnecessary expense. We don't do it if you don't need it. If it's not cost effective, we don't want that business. We'll tell you if you don't need it or if you should wait and why. But with a trust, you have a will. We do a new will. It's called a pour over will, POUR, which does 2 things. By law, a later will cancels an earlier will, so it voids your old will. You don't have to worry about that whole thing. And it says, in case there's a loose end, pour it into my trust after I'm gone because my wishes are written in the trust. Gene D says, does the house go into the trust? Yes, we prepare the deed, we have you sign it, we file it. Anonymous, is it better to put a primary home in a trust or transfer deed to a child? Well, you don't want to transfer to a child. First of all, you're subject to all their debts and liabilities, lawsuits, divorces, and they lose that new basis called the stepped up basis on death. If you transfer to a child, you lose the new basis at death. You lose the $250,000 exclusion if you're single to sell the house. You lose the $500,000 exclusion for a couple. So there's no good reason to put in the child's name, and every good reason not to. Russell G, does a TOD deed have a stepped up value? Yes, it does. Dwight B says, thanks. Anonymous, if you have a trust, you still need a will? Yes, the pour over will. Judy M says, are pre-planned funeral in your trust? No, it's not an asset that you're passing. You prepare the funeral, you have a contract, and that's it. It doesn't go into the trust. It is a exemption from Medicaid. Any amount you put in a prepaid funeral account. There's Judy O. What happens if I draft the trust here in New York and move out of state? The trust is portable, good in every state, no problem there. What states are you licensed in? New York, that is it. 12 offices in New York, enough to keep me busy. A couple of questions I wanted to answer that were sent in ahead of time. I can't answer them all, but some are interesting. Okay, so if this house is an irrevocable trust, when you sell the house, how are the taxes on the gain because the increased value counted? It's the same as if you didn't have a trust. 500,000 exclusion for a single, 250,000 for 500 for a couple, 250,000 exemption. This 250,000 again is exempt. Apostolina P says, if someone has revocable trust and needs to file for in-home care or nursing home, when does the 5-year look back start? The 5-year look back is only for nursing home. For home care, there's no look back. You move your assets out of your name, you're eligible for home care immediately. The time starts from the time the assets are put in the trust. So if you add, let's say you add 100,000 to the trust 2 years after you started, well, what you put into the trust at the beginning is 5 years, and then 2 years later you added money, it's 5 years on the new money. So if you add to the trust, it's a look back from the time you put into the trust. Somebody has a trust, they want to know what are the do's and don'ts. They're in the book. You can download my book on the website and go to those chapters under Medicaid, and you can just download those pages if you want. What else do we have here? Is money in joint accounts protected from Medicaid? The rule on joint accounts, all available for the care of the ill person, except to the extent the other person can prove the amount of their actual contribution. So if the other person put in money, they could prove it is theirs. But if you just put their name on the account, you made a joint, no, it all goes for your care. Pooled income trust, Roger M says pooled income trust. A whole other subject, Roger, chapter 50 in my book, download it from the website. I wrote an article on under practice areas on the pooled income trust. Basically, what happens here is if you need home care, how do you protect your income? You set up a pooled income trust. You send them the income. You send them the bills, and whatever bills you have, you're allowed to keep the income to pay those bills. More on the website. Here's Amber S. is homebound, and she wants to know if we can meet. Well, we'll meet by Zoom, and if we reach an agreement and we want to execute a trust, we'll come see you near Columbia University. Philip T. Yes. Oh, okay. Hello, Philip. I know your firm because I pass it every way on my way home. Well, our family, our clients for highly affluent business owners are not experts in elder law. There's more than elder law. There's keeping in the blood. There's avoiding probate. There's saving estate taxes. And then finally, protecting assets for long-term care. Presently, we have our house in our children's names. Terrible idea because they're not going to get the stepped-up basis on death. We want to put it into a trust and get them to them by inheritance. Yes, if you don't have family members, our firm can act as executor, power of attorney, etc. Ken N. Answers your question. Barbara M. says, why do a trust? My kids are fighting already and I'm not dead. They want to know how much money I have. Well, I got a kick out of that. That's kind of funny. Maybe not if you're in it, but come in and we'll talk about that. You still need a plan. And if they're fighting, we can probably fix it before it turns into an all-out war one day, 100 years from now, after you pass. Okay. And that's all we have for tonight. So thank you for handling, let's see. Okay. Does anybody get in a question in the last minute? Should my pension go to my irrevocable trust? No, a pension is income. You keep all your income. And if it's a retirement account like an IRA 401k, it's exempt from Medicaid as a designated beneficiary. The Gifting Power Anonymous is there's no taxes to the recipients. You can give up to 14 million tax-free, so generally not a problem. And I think that's about it. Thank you for so much for coming and for staying to the end and listening. I wish you all a very good evening, and hope to see you all very soon. Have a good evening.